So, a lot is happening at the moment. John McGurk went on RTE primetime a couple of nights ago and basically reduced Neil Richmond to a big pile of lard. And I emphasise the word big. It's not hard, though. I mean, Neil Richmond actually should be used as a guinea pig for the vaccine, because if it causes brain damage or coma or that kind of thing, you wouldn't notice. There'd be no before or after with Richmond. But anyway, John McGurk went on prime time and was polite and was rational and was calm. And the other people who he was up against then and afterwards have been none of those things, particularly rational. But that's okay, because John McGurk did a huge service for us. It was very like in the Hunger Games where Katniss Everdeen fires one arrow and it breaks the Matrix. That's what happened. That's what happened. Of course, RTE and the Irish Times and all of the wokies aren't going to talk about that one. Wokey dokey, but that is actually, what happened. So anyway, Gemma O'Doherty and John Waters lost their appeal in the Court of Appeal of the verdict of Mr. Justice Meenan in the High Court, whereby he refused them leave to take a constitutional challenge of the lockdown. I'm hearing a number of remarks about Gemma and John. I'm hearing a lot of things. But before I praise them, which I will do, I will say this. Justice Meenan is a judge I've been in front of myself on a number of occasions. He's an excellent judge. He's very fair. He knows the law. He listens. He's very quick at administering the court. He doesn't allow a big backlog of people all gas-bagging in front of him. And I felt and I feel that the verdict that he issued with Gemma and John was absolutely fair and was absolutely right. If you put sugar in the tank of your car, do not expect to be able to drive from Dublin to Donegal successfully. That is largely what he said. But people didn't read between the lines of his ruling in the High Court, where he said that the option was open for others to take litigation, which might be a little bit less misconceived. So Gemma and John appealed to the Court of Appeal. The Court of Appeal, and people don't realise this, does not run the case again. What the Court of Appeal does, the procedure beyond the High Court, is that the Court of Appeal and or the Supreme Court will read the transcripts of the High Court, read the submissions and paperwork of the High Court, and evaluate whether or not the High Court judge was wrong. So an appeal beyond the High Court isn't like when you appeal a conviction in the District Court and it goes to the Circuit Court and they hear the whole thing again. What they do is, beyond the High Court, they evaluate how well the High Court judge conducted the case. What the Court of Appeal said was what I said. Judge Meenan did nothing wrong. Yes. Now, people have been saying to me, well, Poindexter, what would you have done instead? Had you been wanting to take a litigious challenge of the COVID-19 lockdown and all the rest of it? Well, here's what I would do. I would forget about the judicial review route. I would even forget about the constitutionality. Because that is a waste of time. Don't forget, precedent can be set in any case in the High Court, Court of Appeal or Supreme Court. It doesn't have to be a constitutional case. Precedent exists from mainly the rulings and particular observations that the judges might make and stuff they write in the rulings. What would I have done? Well, first of all, I would have done nothing up to now because I haven't been prosecuted and I haven't suffered. Nothing has happened to me. I haven't lost income, thank God. My parents and I haven't suffered, thank God. So first and foremost, I wouldn't have a case because you can't really take a case on abstracts. Theoretically you can, but you can't, So, the lockdown, as much as I disapprove of it and as much as I disapprove of everything that's been happening for quite a long time, but particularly 2020, it wasn't a situation where I could say, well, I have a case here. I haven't been damaged by it. Okay, right, we would have liked Mum and Dad and myself maybe to have gone to a hotel in Donegal. She had her 90th birthday in 2020 and she was crying. She was saying, I would have liked to have gone away from her 90th birthday. I said, there's a lot of people who would have liked to have made their 90th birthday. Get over it. I'll be robust about this. We didn't get to go down to a country hotel for your 90th birthday. There's other people who suffered worse. So I do not have a constitutional right or an inalienable right to take my 90 and 91-year-old parents to a country hotel. So I really don't think that was one to litigate against the state for. You know, I know how that one would have gone down in court. Judge, I'm asserting my right to bring my parents to a country hotel for Mum's 90th birthday. I don't think that would have rolled. So, leaving aside the fact that, yes, indeed, we haven't been able to go to a country hotel for my mother's 90th birthday, or indeed my father's 91st birthday in November, other than that, we haven't suffered. And besides, you don't have the right to go to a country hotel for your parents' birthday. So, you know, I wouldn't have a case. I wouldn't have an injury that I could claim, or a trespass, or a loss. Many other people do, and I'm not being flippant now when I say that. Well, I'm looking around. I'm looking at the poverty and the despair. I was talking to one person today, and I said to him, you have to be Mrs. Carmody in The Mist. She just kept going. Until they shot her, actually. But she just kept going. She was brave and she was fearless. And Gemma and John are brave and fearless. And I do commend them for that. Well, what would I do, though? Let's say now, let's just say, hypothesize. Let's say I'm put through a prosecution for not wearing a mask. Let's see. What would I do? First of all, I would put in a defence to it. In other words, I'd defend it. I'd enter a not guilty. The way that works with the masks is, first of all, the guard apprehends you. And the guard, I emphasise to add this, should ascertain whether or not you actually have permission to be in the shop or wherever without a mask. That happened to me. The guards came down. They ascertained that I had permission to be there without a mask. And they said, well, we're out of here. And they cautioned the individual who had wasted their time, because they discovered then, and the manager of the shop said, we told it to the complainant. We told this man that Mr. Morris is entitled to be here without a mask. So the guards cautioned him for wasting their time knowingly. So, you know, the end. But let's say the guard comes down and takes your name and address, and as it so happened, those guards who came to the supermarket knew my name and address anyway. They just happened to know me. Let us say that you are issued with a fine notice. The first thing you do is you enter an appeal, because those fine notices actually have an appeal procedure. It's not well laid out because they don't want people to know their rights, but there is an appeals procedure attached to a fine notice for not wearing a mask. You put in the appeal. They either accept it or they reject it. If they reject it, then you'll be prosecuted in the district court. If that happens to me, I will do two things. I will go to the arraignment, which is the initial hearing, and I'll put in a not guilty plea. And then, now here's where we pull in the High Court. Here we go. I will then seek an injunction against the state, compelling the state to lift all of the restrictions imposed upon this country since March of 2010. The lockdown, the 5 kilometre thing, all the rest of it. The closing of pubs, all of these things. I will seek a simple High Court order compelling Ireland, which is one of the defendants, the Attorney General, another one, the Chief State Solicitor, and the Minister, to lift without delay and permanently all of the restrictions. You see, there's something else. And I haven't told anybody this because I was sitting on this. My parents and I got tested for COVID. Now, none of us has worn a mask. None of us has followed any of the guidelines in relation to social distancing or any of that. We haven't broken the law, but there is a distinction between, the freemen and the land say, it's not real law, it's not blah, 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 but, it's law, yes. The law pertaining to 5 kilometres and the statutory instrument pertaining to masks, yes, they are law, but I haven't broken them. The things about social distancing and not kissing men on the lips, they're guidelines. So if they're guidelines, then they're not law. There is that distinction, and all the free men D-wall.
Hello, baby boy. I can't. Who's in the house? Pass me my glasses. Jerry, wake up. Jerry, wake up. Pass me glasses here. Let's see who's in the house. Caden, there you are, baby boy. He's only 8 and he's already. Hey, Caden. Hey, fella, I'll talk to you later. Yeah.
D-wall is not a sound source of advice. I digressed. Both my parents and I got tested for COVID. And we're negative. I'll just say that again. We don't have COVID-19. Not even a little bit of COVID-19. Not even a smidgen of... We don't have COVID-18.5 or COVID 13.2. No, we don't have COVID-19. Neither my parents nor I. Now, considering the way that I've conducted myself over the past 12 months, I should be Ireland's #1 super spreader. But no. No, we don't have COVID-19. That is newsworthy, and I'm serious about that because it shows that, to put it mildly, the situation described by our pals in Montrose in the Irish Times, all the cat ladies in the Irish Times have to take the Coke dust from under their nose and put aside the stale pizza. Put down the Sex and the City box set. You're not going to be like Sarah Jessica Parker. You're just a washed up little hack in the Irish Times. Sorry. Put them down. And accept the fact that those people in Montrose and in the Irish Times have been telling you lies and been deceiving you. If only, and nothing else, they have over-exaggerated the impact of COVID-19. And my hunch is that one of the over-exaggerations, well, that's a tautology, one of the exaggerations is its infectiousness. Because I should be, as I said, a super spreader, considering the way I've conducted myself over the past 12 months. Because I have completely ignored all the guidelines and not worn a mask. And I don't have COVID-19. Go figure. Look at Gemma, look at John, look at all the people who go to their protests, look at all the people who don't socially distance, look at all the people who don't wear masks. Look at all those nasty anti-maskers who the Irish Times have a canary over, and the far right, all our friends in the far right. How many of them have died of COVID? Answers on a postcard. The issue that I digress with is that what is happening since John McGurk, that hero, that articulate, erudite, adult John McGurk, went on telly the other night. What has happened has been the term far right is being so overused by all of the wokerati that it is actually being sanitized. And it's soon, probably by tomorrow or by Monday, going to become a case that it'll be a badge of honour to be called a far-right conspiracy theorist. This is how psychopaths overplay their hand. So by their abuse of the term far-right conspiracy theorist, what they have done is they have neutralised it. Let's look at Gemma and John for a second. Gemma and John went about their case the wrong way. I have explained this till I am bloody blue in the face. First of all, they went for it too early. Secondly, they didn't, as I explained about myself, maybe they wanted to go to a country hotel in Donegal. I can't unsee that image, actually. But Gemma and John did not have a personal issue that they could have raised. Unlike, say, a shopkeeper, a beautician, a hairdresser, And we have a hairdresser who opened in Balbriggan and has become, all the lefties and the wokies are all jumping up and down about her. She went about it slightly wrongly, maybe. Maybe she should have brought an injunction against the state to say, I just want you to lift the lockdown. Another thing you would put in the paperwork for the injunction is, irrespective of the lockdown, I want to be given permission to open my shop. An injunction is not like a judicial review. They have to put in a defence to an injunction. And an injunction stands or falls strictly on what you write, both in your paperwork and then what you give in your evidence, usually in an affidavit. This is why, if they cross my path, that's the route I'll be taking. And will we seek a judicial review of constitutionality? No, I'll just seek a court order to end the lockdown. Leave the constitutionality out of it. Make it easier for yourself. Injunctions are like a sledgehammer. And sledgehammers can be very good. An injunction, it just stands or falls on its own merits. You don't have to claim precedent, or you don't have to be saying, oh, it's unconstitutional, or this, that, and all the other. That's the route I'll take. But Gemma and John have turned into kryptonite. Because the more they are slagged by Waterford Whispers and by all of these ones, the stronger their charisma gets. And I'm not seeing very many people sneering and laughing at Gemma and John now. I don't sneer and laugh at Gemma and John now. I criticised and continue to criticise the way they went about the litigation. But I'm doing it, and even people who are big fans of Gemma and John. I'm a fan of John, not so sure about Gemma. But even, they're saying, well, fair enough to you. You're criticising them on specific points of procedure. I'm not attacking them personally. I wouldn't do that. Not even Gemma. And Thomas Sheridan said something. Apparently, according to the wokies, Gemma drove a young Garda to suicide. Well, he wasn't fit for policing if he's that big a pussy. What is He's a middle-aged harpy who's given out to him with South Dublin. Oh, how dare you? With their South Dublin accent. You call yourself a police officer, that's going to drive you over the edge. Gemma bloody O'Doherty. Are you kidding me? Go off and dance Jerusalem. Honest to God, Gemma O'Doherty's going to push a police officer over the line. Well, I'm terribly sorry, because suicide's always a tragedy. Of course it is. But then this person really wasn't maybe fit for policing if a middle-aged harpy like Gemma O'Doherty is able to drive him over the line. Imagine if he was up against, I don't know, the INLA. So, all of the anything people are saying about Gemma and John, it's just adding to their charisma. Now, let's talk about legal costs. People are saying, oh, well, the state shouldn't have to pay for this. The state wastes money on God knows what every day. The state's legal costs with Gemma and John might be, I'd reckon, 200,000. That's what the state had to pay to use the legal team that the state used. Don't forget there was really only one legal team needed. So, okay, there was a number of different defendants. But what happens is if there's one legal team, there's one set of costs. So it's not going to be like there was 5 legal teams in there. That's a biggie. But there's another thing that some of the cheese brains out there are saying, oh, who's paying for them to bring the litigation? Ever heard of being a lay litigant, you cretin? I brought 2 judicial reviews in 2020. Each of them cost me less than €500. I then became party in January 2020. Actually, Justice Meenan granted me the order. I became party to a 3rd planning judicial review in Dalkey. That cost me €90. So I became a notice party means that you have full standing and audience before the court. You have the same status as a plaintiff or defendant if you're a notice party, and I was. £90. That cost me. I got it back actually after Port Planola conceded the case. £90 makes all the difference, But for Gemma and John to have brought their case would have cost them the statement of grounds is 190. The affidavit is 30, including the €10 to a solicitor. And any notices of motion, they probably brought it with an ex parte motion docket, that's 60. 60, 30, 190. 60, 30, 190, 280. So John and Gemma got into the gate of the High Court for €280. And their appeal would have cost them 250. Just 250, not 250,000, just 250 for their appeal, because to lodge an appeal out of the High Court to the Court of Appeal is €250. Same with the Supreme Court. Because the dummies out there don't seem to realise that if you're not using lawyers, then you don't have to pay for lawyers. How simple is that? So the problem for Gemma and John was, first of all, they went about their case very badly. And secondly, their behaviour in court, because I read the transcripts, was fairly cringe as well, to be honest with you, because judges don't like being called corrupt. At least if you're in front of them looking for a court order from them, it doesn't really help. So a lot of Gemma's conduct in particular, I mean, I read the transcript. At one point, Judge Meenan says, Ms. O'Doherty, it's 4:15 in the afternoon and we haven't the time for a speech. I laughed when I read that because I could just hear that. So they didn't know at the start of the... Well, first of all, they should have gone for a simple injunction. Secondly, when you open a case, usually it's with judicial review, but it's with any case really, you can seek what's called an anti-suit protective costs order, which in English means that if you think it's in public interest to bring the case, you are protected from having an order of costs made against you, even if you lose. I got that in all those judicial reviews I brought in 2020, an anti-suit public interest protective costs order. So even if I lost those 2 judicial reviews, I lost one of them and I won another one on the flimsiest of technicalities. Actually, God, yeah, I know, I won a case. Makes a change. But even if I had lost, I wasn't going to be facing an order of costs. But that's also because I was challenging planning issues, and the statute regarding planning permission has a very strict and well set out procedure to go to the High Court, and I followed that procedure to the letter. So I wasn't doing what Gemma and John did. I was going about it the right way via statute, and indeed, you know, the barristers of the other side in court on 2 occasions commended me for sticking to the rules so well, and also trying to get things moving quickly and efficiently. That's how you make sure that the judge doesn't basically hate you. That's the way I'd put it. How you make sure the judge doesn't hate you. Gemma and John weren't quite so effective in that regard. And Meenan is courteous. So whatever criticism is coming out about the results of the Gemma and John case, I assume they're going to go to the Supreme Court at this. It wouldn't be Gemma and John if they didn't, sure. You know, but I'm not amenable and I'm not willing to be silent in criticism of Judge Meenan. And I'm serious about that. And then when I read the verdict of the Court of Appeal, John wrote an article about it, and I, as much as I regard John, I regard him very highly, I disagree with his claims in that article, because if you accept, and I do, that Judge Meenan was right, then, you know, the Court of Appeal merely said, yes, indeed, Judge Meenan is right. So, as much as I do respect John, and I have a certain kind of fragmented respect for Gemma, it's not right to suggest that the court was wrong in the High Court or the Court of Appeal. It wasn't. I've read those rulings. I've read, you know, both the High Court ruling of Meenan and then this week's ruling of the President of the Court of Appeal, Justice Birmingham. I don't think there's anything particularly wrong with them. Because it's what I said earlier. You want to go to Donegal, you don't put sugar in the engine. Or baby oil. So, you know. But this is where we're at, and it doesn't change the fact that Gemma and John have transcended all of this anyway, like the men in 1916 did, and I'm drawing that comparison seriously. The men of 1916 knew they were doomed. And in recent years, in the past 5 years, I've begun dreaming about the men of 1916. And I've begun thinking a lot more about those men. They knew that they were going up against the British Empire in the second city of the empire being Dublin. They went into what they were doing knowing that they would lose and that they would be executed. Plot spoiler, that's what happened. And they went in with their eyes open. And I find it very difficult to understand the level of bravery that took. I cannot get it into my own head that I would ever be in that situation. To knowingly and rationally enter that situation knowing that I was laying down my life. But that's what they did. I've been recently just got interested in the history of certain parts of Dublin. Look it up, the tall houses of Summerhill. Summerhill is a part of North Inner City Dublin, North Central Dublin. And in the Georgian period, before the Act of Union between the Kingdom of Ireland and the Kingdom of Great Britain, the Georgians built a lot of houses around Summerhill, Gardiner Street, Foley Street, Montgomery Street. And the houses in Summerhill were 6 stories high. And there were 2 windows wide. And they'd 1 toilet and a shed down in the yard and a tap. So they weren't exactly Henrietta Street or Fitzwilliam Square. Not quite. They weren't great houses. But by 1900 and 1910, they had degraded into easily the most depraved and squalid slums anywhere in the world. And there was starvation, there was disease, there was overcrowding. In some of those houses, there was over 100 people living in them. And the government was doing nothing about it. And the people were getting more and more desperate. In 1913, a house in Church Street collapsed, and I think about 15 people died. 2 siblings died. A 17-year-old boy died when he went back in to rescue his younger sister. These were desperate and very badly neglected people. And nothing was being done. And it was the Dublin slums, the Monto in particular. The Monto was a very, very squalid slum. They were what led to 1916 directly. And it was what John McGurk said. This is what happens when people have nothing to lose. And we have entered that situation again. We have these psychopaths who are not listening. This time now, the war is being fought. We're not going to go and hijack the GPO. Or Liffey Valley or the Dundrum Centre. Wouldn't that be a great place for a rising? The Dundrum Centre. No. Let's not do that. We're not going to do that. We're not going to have a physical rising this time. We're doing it online, and we're doing it by attacking the mainstream media, and we are winning this one. Don't forget something. And Gemma and John haven't forgotten it. That although those men died in 1916 or were executed, what they did on Easter Sunday 1916 has led directly to the creation of the Republic of Ireland. And I think it wouldn't have happened otherwise. So, Gemma and John are right to do what they're doing, and I support them. I support them with every fibre of my soul. I support Gemma and John for what they're doing. I wish both of them the very, very best. I wish them every success. It is unfortunate that they launched this particular process the wrong way. That is unfortunate. But their hearts are in the right place, and what they're doing is such a good and noble thing. And I'm looking at them, and as Thomas said, they came out of the court laughing anyway. And they looked full of themselves because they know their charisma is growing. And they know that John McGurk and all of these people, all of us out here, we're all doing our bit to destroy the monsters who are doing to this country what was done before 1916.